Hello, my name is Dana Ingram. I am the Executive Director for JC Vision and Associates. And today we are having a discussion on tenant landlord issues and reimagining the Fair Housing Act under the tenant landlord law. We ended our discussion, the last discussion, we were talking about walking into a place and looking at your lease and doing a walkthrough. And Mark, you had ended the last discussion talking about going to that first home inspection and apartment inspection. Why is that so important?
What a lot of people don't understand is when you go and you do your move-in inspection, that points out all the damage that's done in the residence prior to you moving in. Everything that gets put on that sheet of paper, whether it be the house not being clean, nail holes, chunks of the wall missing, damage to the carpets, leaking faucets, anything that gets put on that paper are things that you are not financially responsible for once you move out of that apartment or that house. So you want everything annotated on that inspection.
So is it a good idea to go ahead and take pictures for yourself for a record? What other things can they do to make sure that they are covering themselves?
Yes, absolutely. Take pictures. Snapchat has a filter that gives you the date and time. Use that and take pictures of all the damage that's there on your move-in inspection. Make sure that whoever's doing the move-in inspection, make sure they're annotating everything. If need be, walk room to room with them to make sure they're annotating the damage. That is your time to make sure you are not going to have to pay for anything.
So if they say, as they're doing the move-in inspection, oh, we'll get to that. Oh, we'll get to that. Should that also be documented on that move-in inspection?
Yes, that needs to be documented. If you find anything, make sure you point it out and make sure it's documented, no matter how small, because that saves your pockets in the long run, because any damage that's done during your time in that residence, you have to pay for. Now, what they do is they take it out of your security deposit, but if you go over that security deposit, they can take you to small claims court and file a claim against you for the remaining amount.
So if I have everything documented and then they send me an itemized bill, which I should have, we're going to talk about a move-out inspection, an itemized bill. If I see any of the things that are on that itemized bill that was on my move-in inspection, then I'm not responsible for it. Am I hearing you correctly?
Yes. And then you can dispute the charge during the move-out inspection. You can point out, no, this was here during my move-in inspection. I'm not responsible for that.
And so that I also hear you say that I better have a copy of that move-in inspection and keep it in a safe place.
Mm-hmm. Yes, ma'am. There's a couple of documents that you get right at the beginning of your tenancy that are so important for you to keep your lease. Number one, that is the most important. Your move-in inspection documentation, that is your second most important. Then once you actually get the keys and you go to move in, most places, most property management companies will give you 72 hours to do your own walkthrough and annotate anything that's not listed on your move-in inspection. Well, if you have a thorough move-in inspection, there shouldn't be anything left. But if there is, you annotate it on that, you take pictures of it, and you turn that in, but you always get a copy of that as well, because that lets them know, I found something that your inspector didn't. And then you can't be held liable for it. Okay. So those three documents at the beginning of your term of tenancy, whether it be a house, apartment complex, anything, those are the most important documents that you need to put in the same location where you keep birth certificates, social security cards, because you do not want to lose those.
And if I can add real quick, one thing that I've noticed is when it comes time to listening to your instructions, like you said, when it comes to moving inspection to annotate everything, I have noticed that a lot of times that tenants will find themselves intimidated at that particular moment, and they're still kind of very quiet about things because they're just in that nostalgia of this is about to be my place, I'm about to have this, everything's working out so far, where maybe you were denied at other places and things of that nature, to where you get so caught up that, oh, I'm making it through, I'm about to get this, that you then will find yourself not being vocal on the things that you need to annotate on a moving inspection. So we try to explain to clients and just to the general public that the importance of that moving inspection is like insurance in a certain sense. It gives you a protection whether you realize it today or when you move out. Because that protection, like you just stated, can save you a lot of money where they may try to charge you for a repair that was there before you even moved in. But if you don't vocalize that or write it down because the property manager that went with you was all nice and bubbly and everything, that you are now saying, I don't want to, make qualms, and it's not making qualms. You're letting that property manager or that owner know right then and there that you are responsible person, you are an attentive person, but yet at the same time, you are going to speak out on your rights, and you have a right to do so without any worried about any type of repercussion of, oh, you annotate that, we're going to evict you. No, you need to make sure everything is on there. Do not be timid. Do not be scared to write down what's on there, because even if it's the crack in the blind, don't you understand? A blind may cost $28 at Walmart, but next thing you know, you're paying $228 for this one crack in the blind that gets repaired after you moved out because you didn't speak up on that one small crack. So, like you said, from a nail hole to a tack hole to a crack in the blind, speak on it, annotate it, take a picture, because that protection is going to be so valuable to you when it's time to move out.
Yes, and if anything, if at all possible, if you have a laptop, take the pictures off of your phone and put them on a thumb drive, and put those with your lease. That way you always have a copy of the pictures.
Good point.
Because to dispute a charge when you go to move out, you would need a picture showing the date and time as evidence that that was there when you moved in.
And it being 2023, other than a thumb drive, email it to yourself.
Yes.
Very good. So I hear that I should have a written lease, one that I have reviewed thoroughly to know, and we talked about that in the first session, thoroughly knowing what I cannot have, what my responsibilities are, what the landlord's responsibilities are. I hear talk about the moving inspection, what my responsibilities are and what the landlord's responsibilities are. And now that I've moved in the place, I've been there, let's say 3 months, and now something breaks. What do you think is the tenant's responsibility, Mark, on if something breaks? How do I go about notifying the landlord?
Okay, some landlords now are using apps like AppFolio, and there's a couple other ones out there where you can go into the app and you can do a maintenance request through the app. The good thing about using AppFolio or one of the apps like that is it automatically documents your maintenance request. Some places are still, you have to come into the office, you have to fill out a form and submit the request that way. If it's one of those where you have to come in, submit a form, make sure you get a copy of the form to show that you actually did submit it. That way you have
a picture of it.
Yes, take a picture of it. That way you have a record showing that you actually submitted it. That way there's a tracking system. Normally, once you submit a maintenance request, normally within 72 hours, they're supposed to reach out to you to let you know, hey, it's been submitted. This is who's getting it. Somebody will be in touch with you. And then a reasonable amount of time is 2 weeks to get somebody out.
Right.
But always make sure you do written maintenance requests, whether it's through the app or in person.
So I heard you say a reasonable time is 2 weeks. Some people might say it's hot, it's 110 degrees in southeast Georgia. Is that 2 weeks a reasonable time, or is that something that it should be shorter because of how hot it is?
In that situation, if it's above 80 degrees inside the house, that is considered an emergency work order. Those they are supposed to have completed within 72 hours because it's listed as an emergency. Unfortunately, when it comes to heat, that's not considered an emergency, even though it could be, cold, even though here in southeast Georgia it doesn't get as cold. When it comes to dealing with heat inside of your home, it's not that big of an emergency. But during the summer months, if it's over 80 degrees inside your house, that is considered an emergency work order.
So that's an emergency work order that should be done in 72 hours.
Yes,
However, if that landlord is not going to do that, and I've followed the procedures that's outlined in my lease, and I've gone to the portal, submitted that, I still haven't heard anything, can I go ahead and fix that issue?
Yes, ma'am. Those are called rent and deduct. Once you've given a reasonable amount of time for your landlord to react, and you have your written documentation showing when you submitted the request and that it's an emergency, and then failing to act, then what you can do is you can do what's called rent and deduct. All you have to do is notify your landlord via email, text message. Don't do it via phone call, because then there's not a written record. And then it could be he said, she said. Always notify them in writing that since they failed to make the repair and it is an emergency, you're planning on doing rent and deduct. And then you could pay to have the repair done, give a copy of the receipt for the amount you spent, and subtract that from your monthly rent.
Now, does the landlord have to accept that, or is it something that, or to say, yes, you're authorized to go ahead and rent and deduct, or is that the next rent payment? Am I allowed to do that and submit that?
You're authorized to say it's the 15th of the month, and you're at that point where you're about to do rent and deduct. You notify your landlord in writing, you pay to have the repair done. Your next rental payment, you can deduct that amount from that. A lot of times, once you notify them that you're planning on doing rent and deduct, a lot of landlords will at that point, they will actually expedite it, because most of them use that home warranty process where it goes through almost like an insurance company to make the repair. But if you're planning on doing rent and deduct, now you're hitting them in the pockets.
Gotcha.
So they most of the time they will jump on it.
Okay. So, but I can't go ahead and say I'm not paying my rent.
No, ma'am. In the state of Georgia, there is one rule that you must follow. You have to pay your rent. No matter what's going on, you have to pay your rent. The only exceptions would be if there is a situation where the residence was damaged by like a storm and you have a written agreement with your landlord not to pay rent while they're making the repairs necessary for you to move back into a safe and sanitary house, for you to use that to pay for your hotel stay or something like that. But you would need that in writing. In the state of Georgia, you have to pay your rent. You are not allowed to withhold rent because they're failing to make repairs.
Okay. However, let's say here's a scenario, and we had a case similar to this, where it was very hot in southeast Georgia, and there was a multifamily housing place, and what they were doing was the air conditioning system went out in the building.
Okay.
So they were handing out fans to some and air conditioning units to others. Well, this particular household had a disabled son that really needed to go ahead and have that air conditioning, but they wouldn't give her one. Something like that, is that a fair housing complaint?
Yes, ma'am,
Very much
because
so.
that is different terms and conditions and a violation under disability, because once you notify them that the child has a disability and needs this as part of the disability, and if they deny it, that is the denial of a reasonable accommodation request.
Now, should that reasonable accommodation, does it have to be in writing?
No, ma'am.
So me just telling the person that my son may have a disability that requires air conditioning?
Yes, ma'am. It's always best if you do put it in writing, because then there is a written record of this, of you notifying them of the situation. But according to Housing and Urban Development, it is not a requirement.
Okay, all right, that's good to know. Sometimes you believe that everything has to be in writing. Well, what about if they tell me that it has to be on their special form?
Nope.
According to Housing and Urban Development, you could write it on a sticky note and hand it to them, and that right there is a notification. It does not have to be on any special document that they have. If they want it on that special document, they could take whatever information that you were willing to provide, because believe it or not, you are not required to disclose all the information that some of the housing providers want. All that you have to let them know is there is a person with a disability. You do not have to disclose what disability, anything about it. But some housing providers try to be too invasive or intrusive and try to dig too much and get too much information.
Good point.
Okay, so what if I'm in a housing now and I develop that I have a condition that now requires me to have a support animal? But when I first signed the lease, it says no pets. Now I'm going to notify my landlord that says, well, I have to go ahead and have a support animal. Now, they then come back and say, well, you need to pay a pet fee, and or we're going to evict you because this was a no pet housing. Can they do that?
No, ma'am. Again, that goes back to the reasonable accommodation request. You notifying them that now you have that disability and needing either the emotional support animal or the service animal. According to the Housing and Urban Development, an emotional support animal or a service animal, they are not a pet. They are a member of your household. They are a medical instrument. That would be the same thing as telling somebody that is disabled you can't have a wheelchair. And you're not allowed to do that. You're not allowed to charge pet fees or anything.
Well, let me ask this other question. So let's say that the pipes broke in my home. Is that the landlord's responsibility to pay me for everything that's been, to fix or repair everything?
That would be the landlord's responsibility to repair the property. Now, as far as your individual personal property, you can try to work something with your landlord. 9 times out of 10, they're going to tell you you should have had renter's insurance. So if you are renting in a location, I strongly suggest getting a renter's insurance policy to cover your personal property, because landlords, 9 times out of 10, it will even say it in your lease, they are not responsible for damage to your personal property.
Good point. So it is really important for people that are renting to go ahead and have renter's insurance.
Yes, ma'am.
That happened to me. We had a problem that we were living in an apartment complex, and in the back of our house was a big pond. And when it rained a lot, the pond would overflow. And one time it overflowed through the house, from the back of the kitchen all the way through the house. And the landlord said, if you would have read your lease, it said if that pond ever floods, we're not responsible for your personal property. The good thing was we had renter's insurance.
Wow.
Yeah.
You know, one thing I've noticed in today's time is the fact that a lot of leases will have that as an automatic requirement.
True.
You know,
True.
I've noticed that in my time here that at reviewing leases, that is actually a provision that's being put in inside contracts or leases for you to make sure that you have renter's insurance before actually acquiring this place. And sometimes it can seem, having to explain to clients that this is actually a good thing. It may be costly to you at first, but this is actually a good thing because you're protected. Your stuff is protected. Anyone inside your home that may get injured is now protected, or their medical expenses to a certain extent can be paid for because it happened inside your home. But with renter's insurance, that would take care of that.
Now, if my landlord decided, because not only did my property get flooded, but some of the other tenants' property got flooded, and they came back and said, well, we're going to give everyone $500. But then they come to me and says, well, because yours wasn't as bad as everyone else, we're only give you $200. Is that a fair housing complaint?
Yes, ma'am. That's no different than saying you're not as close. You're 500 more feet away from the pond than everyone else's unit, so therefore we give you less. No. If anything else, if you put in the provision that this pond floods and you got to get renter's insurance, that's no different than everybody in that area. You give one person 500 for that pond flooding and messing up their property. If anyone else got damage from that property on their property from that flood, you got to give the same amount.
Well, does that mean also that I have to be in that protected class, though, too, under the Fair Housing Act?
Yes, it does.
Okay.
It does.
Okay, so it's probably, that question was a little bit more, it needs a lot more layering and more detail, because we would have to find out who else got the $500 and
Correct.
what is what class are they in,
Yes,
to
ma'am.
see if there was any discriminatory issues that went ahead and put you into another category of maybe because you had purple eyes and we only gave people with purple eyes $200 and
Right.
not the $500.
Even then, there's still the realm of some different terms and conditions, but no, purple eyes is not a protected class, so therefore.
But I was just using that
Yes,
example.
ma'am, but that's a great example, and I understand what you're saying, and you do have to look at those things, especially if someone to bring that to our attention or to our desk. That's going to be a part of our process. Is we're now going to try to find out all the protected classes that did get the $500 to see what's the difference between them and this protected class, why they did in order to file a complaint with HUD possibly.
Right.
So yeah, that makes total sense.
Well, let me ask this question. So now that I may have a disability and I make it a reasonable accommodation in writing, let's say, for instance, I need to go ahead and get a parking space because now I'm in a wheelchair. Now, if they do not grant me that a reasonable accommodation, is that a fair housing complaint?
Yes.
Yes, ma'am.
Okay.
Your reasonable accommodation request is making an exception to an existing rule. So your landlord can say it's park wherever, park in the available spots. You don't have a designated spot for your apartment. But with you now having the disability and needing, access to the handicap spots or a parking spot that is the closest to your unit, they can actually put up a sign and designate that parking spot for you. Because that is the reasonable accommodation request, is you designating that spot for that individual.
Okay. Well, let's just twist it a little bit differently. What if, and we only have a few more minutes.
Okay.
What about if I have children in my household,
Okay.
and there's a pool, and they say that children are only allowed to go ahead and play in the pool from 4 o'clock to 5 o'clock. They can't play any other time in that pool. Is that a fair housing complaint?
No.
Well, I got two different answers here.
Really?
Yeah.
Well, because of the fact from the training that I've always looked at is the fact that is more deemed as a safety provision, that to say that they can't be at a certain time compared to saying no children allowed at all.
Well, Mark?
Looking at it with some of the new information that has come out recently, that would be because now you're discriminating against families with children by saying you can only use this amenity at this apartment complex for this 1 hour, whereas you're letting individuals that don't have children use it all day. So now you're limiting when children can actually use one of the amenities for the apartment complex.
Very valid point. And I was going from experience of that. The defense to that would be that there would be a safety provision, and it does get to splitting hairs. But I understand exactly wholeheartedly what you're saying, because I still too will probably file a complaint.
Right, because if the lease says that I have amenities, the uses of the pool during the times that it's open, and the pool is open from 8 o'clock until 7 o'clock, then it doesn't matter what time, I want to use it. I should be able to use it during the time of 8 to 7 with my children or without my children.
Totally agreed upon, and that's what I was saying is the fact that that's a great question, but at the same time, I still file.
Right. Well, we're at the end of this session, and I want to thank you very much for being here today. We join us at our next session, and we're going to get a little bit into the move-out inspection and eviction process.